The Second Amendment, as I'm sure you all know, is part of the Bill of Rights. It's only 27 words long. It's, in fact, I believe, the shortest sentence in the Constitution. It reads in its entirety, "A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed." And what people don't recognize, what people are often surprised to learn, even aficionados are often quite surprised to learn, that the Supreme Court of the United States never ruled that that Second Amendment recognizes an individual right to gun ownership until 2008. It was really recent. The Second Amendment was originally the Fifth Amendment. That was part of it. Well, what did they mean? What do those convoluted phrases mean? Part of the answer is we can't entirely know. We know that their thinking was very different, that they were very focused on the militias. We know that it's hard to pierce through the fog of history to fully know what they mean. But the fact of the matter is this, and this is a surprise when you think of how intense the debates today are about gun rights and the individual right of gun ownership for things like self-protection or hunting or anything like that, all the things we think about and talk about now. There is not a single word in the notes Madison took of the Constitutional Convention, in the records, with a few scattered exceptions, of the ratification conventions, or on the debate on the floor of the House of Representatives about the Second Amendment. There's not a single word about gun ownership, protecting the right of gun ownership for personal protection or hunting or anything other than malicious service. Not a word. In fact, Madison's original proposal for the Second Amendment had a conscientious objector clause. It said if you have religious scruples about bearing arms, you don't have to do your military service in person. That's actually the wording. And that's what they debated. It was all about the militias. That's a surprise to people. People ask me, as you can imagine, so what was it? An individual right or the militias? And the answer is it was both, and it was neither. It was an individual right to fulfill the civic duty to serve in the militia. Our question would make no sense at all to the framers, just like in some ways their answer makes no sense to us. Now I want to be very clear. There were plenty of guns, and the colonists and then the Americans believed they had the right to protect themselves. There was a right under British common law. Blackstone, the great jurist, wrote about it. They had a right to protect themselves, especially in their homes, but it was governed, as I say, by common law. And they didn't think they were necessarily putting that into the Constitution. And at the same time that they had guns and the expectation of being able to own guns, they also had ubiquitous gun laws and gun safety laws and gun control laws. Here in the city of Boston, it was illegal to keep a loaded gun in your home for safety reasons. They blew up. In other cities, including Boston, Philadelphia, you couldn't fire a gun inside city limits. There were all kinds of limits on who could own guns. You had to have a loyalty oath. The wrong kind of people weren't allowed to have them. There were plenty of gun laws along with guns. But as I say, those were considered to be state law and governed by criminal law and common law and not something they thought they were putting in the Constitution.